Welcome back, everybody, to the Aaron's High Cap Adventure Radio program, February 16th, 2019. And to my left sits attorney extraordinaire Benton Ross Watson. Ross, how's it going? But I hear you're down with the flu.
Man, it's great to be here. I'm getting my First Amendment rights impinged.
You taking mine away. Okay.
Yeah, respectforyou.com. We're here to talk about the respect that the framers and founders had for you when they enacted the Bill of Rights.
Oh, you said that right. What they thought of in the future of how it's supposed to be, man, the way they wrote it is fantastic. I'll tell you what, let me start it off. Tell you why we came up with this. I mentioned it earlier in the show. I was reading a news article, or I listened to one, I can't remember which one it was, but I heard a soundbite saying a lot of illegal immigrants are coming in and not understanding the foundation of this country and the Bill of Rights, Constitution, and they're not blending into our culture. It's almost like you came in here, but you're still separate, and you don't understand how things work here, and you want to change the way your thought process is, and that doesn't work. Sorry, everybody, it doesn't work that way. You come into this country, you're going to work it the way this country set it up. And so we were talking about it, and I figured, why not go over the Bill of Rights? So for the next 10 weeks, we're going to go over the 10 Bill of Rights, and I wanted to give everybody who's not too familiar with how this works a starter course. Now, the Constitution of the United States has a preamble, the opening paragraph. So I want to give you an example of what a preamble is, in case you're not aware of it. This is the preamble to the Constitution. The Bill of Rights has one as well, but I want to get you started. The preamble of the Constitution says, "We the people," and by the way, back in grade school, I was dressed up as George Washington, and I had to read the preamble, so I feel pretty special in this part. "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." Then all the articles of the Constitution, okay? Now the Bill of Rights, once the Constitution was ratified, everybody says, hey, you know, that was fantastic, this is great, but we want to write something to clarify, to make sure, to add to it, to make sure there's no misunderstanding of what we're trying to say. So here's the preamble of the Bill of Rights. This is Congress of the United States begun and held at the city of New York on Wednesday, the 4th of March, 1789. And here it goes. The conventions of a number of the states, having at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. And as extending the ground of public confidence in the government will best ensure the beneficent ends, did I say that right? Of its institution. So what they're saying here is, yeah, we wrote the Constitution, but we just want to make sure everybody's got it right and there's no misunderstandings. We're going to add to it these Bill of Rights. And there you have it. I'm going to read the First Amendment of the Bill of Rights. Passed by Congress September 25th, 1789, ratified December 15th, 1791. The first 10 amendments from form the Bill of Rights, and that's the freedom of speech one. So, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably to assemble and to petition the government for redress of grievances. That's First Amendment of the Bill of Rights.
And just so some folks know some of the history, remember the first part of the Constitution was enacted much earlier than the Bill of Rights was, and we had the Federalists and Anti-Federalists, and we did a good program, I think, that you guys can go find on YouTube that talked about how we wanted the Bill of Rights to come in to protect rights, but everybody thought that these rights were common to man, that they were natural, inherent by God's ordained, or God ordained them himself to man, and they were common to all men. And obviously we had slavery, and so man had a different definition in that day, which I'm glad that we've changed in our country. But as far as this is concerned, these rights go into really delineate what the government can't do, and just to say that we absolutely do have these rights, because a lot of the founders were scared that as government over time grows bigger and stronger, it slowly chews up and eats day to day, week by week, month to month, year by year at your rights. And You know, there was a good argument from folks like James Madison who said that we don't need to put a Bill of Rights because these rights already exist. We already know that they do, and if we put them in there, it's going to make it look like they didn't exist but for the Constitution. And I really respect that viewpoint, and I do agree to some extent. But like I've said many times before, if we would not have had these Bill of Rights, there are things that would have been no limitation on government,
right.
and it's only for the sake of them that government has had restrictions on it. And so it's very important that I think that people know their rights. A lot of times people say, well, I know my rights. Well, they really don't. And so maybe that's what we're hoping to portray here today. And I wish I wasn't as sick, because First Amendment and Fourth Amendment, as I say, are my two favorite amendments. Probably the first to everybody is a very a sacred right that we have. It protects 6 essential rights that we have. And so, as you read, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble, or to petition the government for a redress of grievances. So if you look in here, you're going to see 6, right, that stand out to you. It's going to be the Establishment Clause, right, the free exercise of religion, free speech, free press, peaceful assembly, and redress of grievances. So redress of grievances I'll just cover very quickly. We're just going to make sure that we have a way to be able to get into the courts. Texas has this and an open courts provision. Texas has its own, instead of making its own Bill of Rights, Texas actually put these rights within the Constitution itself. As you'll see later on, like things like the jury trial that were added in the Bill of Rights, Texas actually made, which we talk about the jurors of jury trial. Texas thought the right to a jury was so important that it was in its initial constitution. And so these rights are definitely important. You want to be able to come to government and petition for things that happen to you wrongly, and for things that the government is doing to you. If you had no way to challenge the government, then there would be no way for you to use your speech, because the government could take it and you wouldn't be able to have any way to redress, right, the infringement. Okay? And so you need to be able to have a process to do it. And so that we're also going to see we have due process in the 14th Amendment. So a lot of people don't understand. Well, they say that the Bill of Rights only applies to federal laws. It only applies to Congress. Well, we have the 14th Amendment now that we call incorporated the Bill of Rights to the states as well. So the First Amendment is going to apply to state regulation to the same manner that it applies on the federal level because of the 14th Amendment. And so we're going to have, I'll go to peaceful assembly and freedom of press. We're not going to talk a lot about that because we don't have near enough time to cover these things. But peaceful assembly is essentially a free speech right almost, as well as the free press, because in order to get ideas and opinions, in part of First Amendment law, when we're talking about speech law, we talk about the marketplace of ideas, the United States being the marketplace of ideas, and we try to regulate speech, and the things that how we handle speech law is based on sort of like a capitalistic point of view, right? If there's a viewpoint out there, like you obviously we don't like people burning the flags. Neither one of us do. We've had several heated discussions on here. I'm all for giving the person the right to burn the flag. I'm not for it. I don't agree with it. But if they want to burn it, I'm fine with that. And here's why.
But I back you up on that. I hate it too, but I'll fight for the right for you to do it.
Correct. And the reason is because we feel that. I'll explain it this way. If you've ever seen a kid who goes in to get a shot, a lot of times the doctors will just grab them and put them on the table, right? And then they start freaking out. Ah! They start going crazy, right? Whereas if they would have just approached it and let the kid sort of express a little bit of fear, but didn't just try to compel him to give the shot, it would have gone very nicely. Okay? And that's the same way almost with speech. That if we try to compel people and restrain them from talking, it's going to explode. They're not going to have any way to release their emotions.
That's a way to prove that freedom is a natural right, because you're trying to restrict somebody and that freedom just wants to come out.
Exactly. Okay. And so but we feel that there's no need to restrain these viewpoints, because if a viewpoint is disfavorable, the marketplace, people in general society, is going to reject that viewpoint, and eventually it'll get washed to the side. So we want to give people an out to express their emotions. So we we allow them to do that, and we don't want government to be the one to tell them they can't. And so, in order to have a marketplace and exchange ideas and develop ideas, we have to be able to meet and associate with other people of like minds and of not like minds, so that we're able to get better viewpoints about different topics and issues. And so the right to peacefully assembly goes hand in hand with the right of free speech, because we have to be able to communicate and congregate and be with other people in order to exchange ideas.
I want to ask a real quick question. Shut me up if it has nothing to do with this. Why is it sometimes you need a permit to go and do some type of speech rally?
And that's what we're talking about. So a lot of times the First Amendment is going to be very strict against prior restraint. That would be called a prior restraint, because you're trying to make a regulation before any speech is actually had. And this would be if you have an unreasonable bond amount, an unreasonable permit fee, an unreasonable fee for insurance, say, from a city government for people to march, or you have a time requirement that has to go through this application process that makes it essentially useless to get your message out at the time. And so courts routinely, strike down injunctions and prior restraints permits on people that want to do a parade. Now, the court's very clear that it will uphold penalties if you go ahead and do that Free Speech Act and not pay the permit fee or not pay the insurance fee or not do these things. You can be fined, right? And the city can go ahead and they're going to uphold that. But
okay, I just lost something here. I heard every word you said. I'm looking at you, but then it didn't connect. If they're going to put it down, yet they still will fine you, I don't get it.
So they're not going to allow you, to just avoid any kind of responsibility to pay government. But they're not going to allow government to put in such strict requirements that it makes it burdensome for you to actually get your message across. And so, like I said, you may violate the permit process and go ahead and get your message out there, and the court's going to uphold you if the city comes in and tries to get an injunction to stop you. But you're probably going to have to pay a fine if you violate some kind of ordinance. Look, there's cases all over the place. It kind of is fact intensive, case by case. There's a thing called strict scrutiny. We're going to apply strict scrutiny to any prior restraint. And if it's not the least burdensome, and if there's other alternatives available that they could do, the court's going to strike it down. But we don't have time to get into that. Okay? So this is just a brief overview. So if you've got one of these things, that's what I was trying to tell you. You definitely need to seek out a lawyer if the city or somebody's trying to prevent you from getting a message. And they do this a lot, which we're going to see in the end of this show. We have the freedom of press. That's way too much. But there's a movie that just came out, the New York Times versus Sullivan, which is about the Pentagon Papers things and whether they could publish that, because it dealt with government security and things like that. But it was also things that people needed to know about what their government was doing. And when those things were published, they tried to enjoin them from publishing them, and they tried to come after them. And it was a very important case for the press, and the press does have a need for these rights because it was important in our founding. The Establishment Clause and the Free Exercise Clause are the religious aspect of. You remember when we came from England? Okay, we had the king, and we had the secular courts, and we had the king's courts, and you had statutory laws, and you had equity that was applied by the kings, and so it just became. And then you had the king, which was bound by the church, and there was revolutions fought over this. In every society that there was religion and secular involved together caused problems, and that's why the founders wanted to make sure that we kept our separation, but at the same time we wanted to protect your religious freedom. So there's always, in these cases, there's this interplay, there's this collision course between religious freedom, and government control. And so the Establishment Clause is one from out of Texas in 2005 that maybe you'll remember, where they displayed the Ten Commandments, a monument to the Ten Commandments on the court at the legislature here in Austin. And Mr. Van Orden appealed that and said that was a violation of the Establishment Clause because we're respecting an establishment of religion. And the court actually upheld Texas's right to put the Ten Commandments on the legislature square out there, because that was more historical and secular. It was a traditional kind of thing. It went into the creation of Texas.
Isn't it almost like a mission statement to this country and to this state? It's because this country and this state were basically raised up on Judeo-Christian values, and those are basically pillars of those values. And all it is a mission statement saying, you know, in this country, we're definitely going to uphold those values.
Some of that is true, yes. As far as the legal aspects of it, I totally agree with what you're saying, but from the court standpoint, I looked at it as more of you putting an antique piece of equipment at your business property as you know, if you do agricultural law, for instance, and you put an antique piece of farm equipment out there, it shows who you are. It's an identity. It's an identity thing, and that kind of showed who we are, which is what you're saying.
Okay, I get
that it goes to the pillars of why we were created and how Texas, what we stood for.
All right.
Okay, and so the free exercise clause. There's some fun cases, and I'm going to point to two here that I think is very funny because they're cases that are advocating sex and drugs. So it's the government, right, essentially regulating practices, and the religious folks coming in and saying, but we want to do these types of practices, and that's our right to do these kinds of practices. And they were Reynolds, which was an 1878 case, and the city of Boerne versus Flores. And there's also another case, I can't remember the name, that talks about the use of peyote, okay, within the religious ceremonies. Peyote was upheld, right? It was an Oregon case, I think. Peyote was upheld. Oregon, in many cases, other times it's not been upheld. And so the defining point in these is whether it's a religious belief, right, or whether it's a practice that the government can regulate. And so in Reynolds, it was polygamy. It was the Mormons, the Latter-day Saints, and whether or not you could have multiple spouses. And I'm all for it. I don't know how this can be justified today, right? Especially now that we have gay marriage that's being approved and it's seen as a constitutional right. I think that we're going to see more cases as far as polygamy is concerned. And hey, if you want to have more wives and more kids, all more power to you, man. But I got a humanized dog and a girlfriend and an office manager, and I can't handle any of them. So let's just a few wives and few kids. And so, I mean, if you want more spouses and more kids, in my opinion, more power to you, and I will fight for your right under the free exercise clause for that right. I don't even think it comes down to a matter of free exercise clause. I don't even see why the government is so against this anyway. If you look in the initial cases and you look at cases out of Texas,
that's punishment enough.
Right, exactly. And so if you look at the cases out of Texas for polygamy and bigamy cases, you're going to see that, man, it's really antiquated, the policy reasons that they use to uphold these, and it's not really justifiable under today's policy reasons. So I really think we're going to have more of these. But then we had City of Boerne versus Flores, a 1997 case, and this was out of San Antonio. The Catholic Archbishop Patrick Flores applied for a building permit. He wanted to upgrade his 1993 mission style building because his congregation had gotten too big, and the city denied him a permit to do that. And then so he appealed under the Religious Freedom Restoration Act, RFRA, okay, and essentially the court shot RFRA down. Okay, it said that because Congress essentially in the Religious Restoration of Freedom Act made it where any kind of law that was restricting religious activity would be applied what we call strict scrutiny, which is a very hard standard for a government to meet. I mean, it's extremely difficult for a government to justify one of its laws under the strict scrutiny standard that the courts analyze, right, those kinds of laws under. And so the court was like, you can't make RFRA say what the courts do. You're trying to tell the courts what to do with this act, and it's a very complicated case, but essentially the city ended up winning that case. And it is important, though, going forward for us to determine, right, exactly what free exercise means. And so does it mean that we can't have regulations? Congress can absolutely come in and make regulations for or against religion, but ultimately it's going to be the courts, whether Congress is congruent and proportional, right, whether those laws are congruent and proportional, right, for religious activity. If we're also going to, matter of fact, this was Anthony Kennedy was a swing vote on this. So these kinds of cases may change with new additions to the court that we just have. And I'm talking about these cases because they're controversial, right? And we're just going to have to see. I think that there could be some change in these coming up in the near future. Okay, and so know that you have the right to a religious belief, right? But sometimes your practices, what you do, your activity can be regulated by government. Okay, and so even though your beliefs and your religion can't, but sometimes whether it's a practice that's really part of the religious belief, right, is a gray area, and the courts have to step in and decide that. So free speech. So we spoke about, you're going to have, first question is it speech? Flag burning, is it speech?
Yeah.
How?
It's an expression of opinion.
Is it? Is the flag itself speech?
Yes, it represents.
Or is it an object?
It's an object that represents what we, how we are in this country. It has many quiet expressions of who we are.
Exactly. So it's what we would call a symbol. It's a symbol of what we are, who we are as a people, what we represent, what we stand for, where we came from. And these types of symbols, even though they are not in itself verbal, right, they are more expressive often than what we could say. Yeah. A picture is worth 1,000 words.
You look at the flag, my heart swells.
Exactly. So
okay.
Yeah, exactly. And so symbols a lot of times have more expressive value than what we could say. You know, what 1,000 of us could say. And so they're very important. And so yes, a lot of times the courts do have to decide as something expressive, but they're very open, and it's a broad view about what is expression. And so many times silence in and of itself, right, is expression. And there's nothing more beautiful than that. Okay, I mean, so there's oftentimes we have to decide too if is it conduct, expressive conduct, is it a symbol, is it speech, is it verbal, what kind of speech is it, and that sometimes determines what kind of regulations there are. If it's political, it's core speech, First Amendment speech rights, and you're going to get every single right that you can possibly imagine, and you're going to get strict scrutiny. You're going to get the courts on your side almost emphatically, right, when you're talking about political speech. And that's what comes in with campaign contributions, and right, because that's a form. Your campaign contribution goes to advance a political point of view. And so there's been free speech
You're just
cases,
basically paying somebody else to say your thought process,
which is you're essentially your agent, and it's your group. It's your right to assemble with this group,
okay,
right, for your group to advocate this point of view. And so you see how, as we go through this in the Bill of Rights, all through all 10, you're going to see how each one has this interplay, and each one is just as essential to the preservation of the next. Mm-hmm. And so while for the First Amendment is very important, and it gets a lot more right protection than other rights, the First Amendment could not exist in many aspects were it not for those others. And so in each single subset of First Amendment speech often depends on the protection of the other subset. And so as we go through this, I want you guys to notice that. And so here, right, then too, we got famous cases. Texas versus Johnson with the flag burning case. We got Morse, which is the marijuana at school, bong hits for Jesus case. We have, what are the school kids' rights? And you have famous court cases, opinion, Tinker, which is the black armbands, which was almost a silent protest against the Vietnam War. Okay, and Tinker actually won. Mr. Morse was not as successful, right, in his bong hits phrase, but one has a very core political reason and is should be protected in school, whereas the other is an illicit purpose, a drug use that schools have a right to regulate. And so obviously those are two ends of the spectrum, but you can see how at some point you're going to have these two colliding with each other. Where does it end? And the courts have been very adamant that the students' First Amendment rights do not end at the courthouse step. Okay, and so, but what they are and how they're regulated, we talked about on a couple of shows. And so I think, how close are we? How much time we got?
We're good. We got about 7-8 minutes.
That's perfect. So Justice Jackson is probably my favorite Supreme Court justice, and if there's no one better to illustrate, right, the importance of the Bill of Rights than somebody like Justice Jackson, who essentially came from a very modest family, came from nothing, right, was one of the only, or is the only justice on the Supreme Court who did not right, go to law school, and he essentially was a apprentice under other lawyers for a while, and he got his license that way, and just rose in the ranks and went through the Judge Advocate General's office, and then became a prosecutor for the government, and then became he actually prosecuted the Germans at the Nuremberg war trials, and he probably could have had Chief Justice spot, but he thought it was his duty to go to the Nuremberg war trials and sacrifice to do that for his country, and essentially gave up the Chief Justice spot in the United States Supreme Court, and wrote some of the most seminal, most important opinions in American history. And if there was one opinion that I would pick to put in a time capsule, if America society, right, was destroyed tomorrow, and save and preserve for generations to come.
I'm kind of worried about that, to be honest with you. Go ahead.
Well, and to preserve it and to really say what we stood for, it would be Justice Jackson's opinion in West Virginia State Board of Education versus Barnett, which was in the 1940s. It was in 1943, right in the midst of World War II. And during that time, we're going to go a little bit over, but this is important, okay?
Do what you got to do.
And during that time, I want to give you guys a little brief background. There was the flag salute. And the flag salute, if you remember the Nazis, their salute was their hand out forward, right, looking forward, body straight, right, with their hand, palm of their hand, right hand turned down. Okay? Well, the Americans, right, we had the exact same salute to our flag, except our palm was turned up.
Interesting.
They were identical except for the palm being turned up. And there was criticism all across the state. And remember, it was a big push in national policy to foster nationalism, motivate the people to get behind the government and the things that they were doing. And so it became regulated that kids had to do the flag salute. They had to do the Pledge of Allegiance, and they had to do the salute to the flag. And so during this time, right, they were actually expelling kids from school. They were prosecuting parents for truancy. They were going after, and the biggest group that was hit the hardest was the Jehovah's Witnesses, because they refused, right, to pay homage to, right, another idol, another establishment, right, other than God. And so that was part of the Ten Commandments. That was part of their religious belief, right? You could see how all of these subsets of the First Amendment start to come into play. And even other groups, ACLU, not just them, there was plenty of other groups that were uncomfortable with making students do this salute, because this was a mere identical image to what Hitler was doing. This made us look like we were little Nazis. In America, we were just as fanatical as they were. And so Justice Jackson is tasked with writing the opinion in this case. And I'm going to read, and I took some excerpts out, and it's 3 pages worth of the opinion, but it's worth your time to go read the opinion. Okay. And so I'm going to do that now. He says, "Here we are dealing with a compulsion of students to declare a belief. They are not merely made acquainted with the flag salute so that they may be informed as to what it is or what it even means. The issue is whether this slow and easily neglected route to arouse loyalties and constitutionally may be shortcut by substituting a compulsory salute and slogan. There is no doubt, in connection with these pledges, the flag salute is a form of utterance. Symbolism is a primitive but effective way of communicating ideas. The use of an emblem or flag to symbolize some system, idea, institution, or personality is a shortcut from mind to mind. Causes in nations, political parties, lodges, and ecclesiastical groups seek to knit the loyalty of their followings to a flag or banner, a color or design. State announces rank, function, and authority through crowns and maces, uniforms, black robes. The church speaks through the cross, the crucifix, the altar, and the shrine. The clerical raiment. Symbols of state often convey political ideas, just as religious symbols come to convey theological ones. Associated with many of these symbols are appropriate gestures of acceptance or respect. A salute, a bowed and bared head, a bended knee. A person gets from a symbol the meaning what he puts into it, and what is one man's comfort and inspiration is another's jest and scorn. Over a decade ago, we approved the display of a red flag, symbol of opposition by peaceful and legal means to an organized government that was protected by free speech guarantees of the Constitution. Here, it is the state that employs the flag as a symbol of adherence to government as presently organized. It requires the individual to communicate by word and sign his acceptance of the political ideas it thus bespeaks. Objection to this form of communication when coerced is an old one, well known to the framers of the Bill of Rights. It is also to be noted that the compulsory flag salute and pledge requires affirmation of a belief and attitude of mind. It is now commonplace that censorship and suppression of this type of expression can only be upheld in the presence of clear and present danger to the state. But here, the power of compulsion is invoked without any allegation that remaining passive during a flag salute ritual creates a clear and present danger that would justify an effort to muffle expression. To sustain the compulsory flag salute, we are required to say that a Bill of Rights which guards the individual right to speak his own mind left it to public authorities to compel him to utter what is not in his mind. If validly applied to this problem, the utterance cited would resolve every issue in favor of power of those in authority, and would require us to override every liberty thought to weaken or deny execution of those that are in power, the execution of their policies. Government of limited power needs not be an anemic government. Without a promise of a limiting Bill of Rights, it is doubtful if our Constitution could have mustered even enough strength to enable its ratification. To enforce those rights today is not to choose weak government over strong government. It is only to adhere as a means of strength to individual freedom of mind and preference to officially disciplined uniformity, for which history indicates a disappointing and disastrous end. The 14th Amendment, as now applied to the states, protects the citizen against the state itself and all of its creatures. Boards of education are not accepted. Such boards are numerous, and their territorial jurisdiction is often small. But small and local authority may feel less sense of responsibility to the Constitution, and agencies of publicity may be less vigilant in calling it to account. There are village tyrants as well as village Hampdens, but none who act under color of law are beyond the reach of the Constitution. The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, a freedom of worship and assembly, and other fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. National unity as an end which officials may foster by persuasion and example is not in question. The problem is whether under our Constitution, compulsion as here employed is a permissible means for its achievement. Struggles to coerce uniformity of sentiment in support of some end thought essential to their time and country have been waged by many good as well as evil men. Ultimate futility of such attempts to compel coherence is the lesson of every effort, from the Roman drive to stamp out Christianity as the distributor of its pagan unity, the Inquisition as a means to religious and dynastic unity, the Siberian exiles as a means to Russian unity, down to the fast-failing efforts of our present totalitarian enemies. Remember the Germans in that case. Mm-hmm. Those who begin coercive elimination of dissent soon find themselves exterminating the dissenters. Compulsory unification of opinion achieves only unanimity of the graveyard. And I'm closing, all right? It seems trite but necessary to say that the First Amendment to our Constitution was designed to avoid these ends by avoiding these beginnings. There is no mysticism in the American concept of the state or of the nature or origin of its authority. We set up government by consent of the government, and the Bill of Rights denies those in power any legal opportunity to coerce that consent. Authority here is to be controlled by public opinion, not public opinion by authority. The case is made difficult not because the principles of decision are obscure, but because the flag involved is our own. Nevertheless, we apply limitations of the Constitution with no fear that freedom to be intellectually and spiritually diverse, or even contrary, will disintegrate the social organization. To believe that patriotism will not flourish if patriotic ceremonies are voluntarily and spontaneous instead of a compulsory routine is to make an unflattering estimate of the appeal of our institutions to free minds. We have intellectual individualism and the rich cultural diversities that we owe to exceptional minds only at the price of occasional eccentricity and abnormal attitudes. When they are so harmless to others or to the state as to that we deal with here, the price is not too great. And I emphasize, freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to the things that touch the heart of the existing order. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur before us.
Wow. That was a lot, man. And it was, every bit of it was very good.
It's a very emphatical, it's a very important decision. It brings tears to my eyes when I read it normally, and it's a very important decision for all rights in general.
You could read that 4 or 5 times and you pick up something that you missed every time you read it.
And so I appreciate y'all being on. I know we went over time, but I appreciate it. We'll try to keep it in the lines next time.
I will have this segment on YouTube probably Tuesday next week, so we can all listen to it again and glean off of it what we can. So we're going to be doing this for 10 weeks. Next week will be the Second Amendment, my favorite. Okay. And just very good. Is that a call for us? I'll tell you what, Ross, hang tight. Let's see what we got here. Welcome to the show. You are on Aaron's High Cap Adventure Radio program. Who do we have?
I have Jonathan here in Temple.
Jonathan, how you doing, buddy?
Pretty good, Matt. Hey, my question is, there's been a lot of the news lately between the federal authorities and even our Texas state legislators about these red flag laws. And I guess my big question here is, what's going to happen with these laws when a group of citizens decide to defend their rights? I mean, how would that play out?
As far
you literally have citizens who would be losing their rights for a court case.
So you're talking about from the First Amendment standpoint, if a group of people were to try to avoid some kind of red flag law.
Well, I'm speaking to the confiscation in general. You know, and let's talk a little more local. I guess your cousin Billy Bob down the street has the ATF or the local sheriff decide that they have their red flag warrant. And they're going to take his firearms. But he has not yet been to court. He has not been found guilty. He has not had any of his rights. It's just a bench warrant basically issued by the police.
Again, you're gonna. Hey, that raises a good question. We talked about that. That's going to be a due process issue. How are they? Under what circumstances they have probable cause to come in there? Under what circumstances is the warrant justified? And we spoke about too how you have mental commitment proceedings, right? Oftentimes those are shot down because the process was irregular. Here, I don't think that the red flag laws, my opinion is that if they go under the current scheme, they are going to be shut down. Okay, you're going to have a certain process. What is the red flag based off of? What is the reason that they're using to justify the red? What does it say?
I don't know, Mom. Keep going.
What is the necessity or justification for the red flag law to begin with, and then what is the necessity or justification for executing on this particular individual? That's all going to come down to a due process issue. It's also going to come down, I think, to the Fourth and Fifth Amendments. I think that you're going to have Second Amendment right interplays. What is this?
These are already happening all over the country. I mean, what was it, Maryland, where the police actually ended up in a firefight with the individual who they were there to serve the warrant on. I mean, again, you don't know why the police are showing up at your door. You've had no trial, no due process. But ultimately, I mean, it ends the same way. If you end up in a firefight with the police, you lose.
Correct.
Even though you've had no due process, you've had no legal representation, yet you are still losing your rights. I mean, what happens when the police are actually out armed?
So obviously my advice to you is going to be comply with what they're doing and get a lawyer and just smoke them in court.
Jonathan, on a low grade level, I would say it's an officer pulls you over on the road, and for some bogus reason you're getting arrested. What are you going to do? Fight them? You comply and then take care of it in court. Although you shouldn't have to do that. That's the smart and safest way to do it.
There's a difference though between a $300 traffic ticket or, you know, some of your listeners have $30,000 in firearms that are being confiscated.
I totally understand.
As well as their right to self-defense.
I totally understand.
Absolutely.
I was just using it as a low grade.
We have not even begun to see the fight and fights that are going to be launched against those types of laws, and I look forward to making money off of.
You said it yourself, Jonathan. If you don't comply, you're going to get in a firefight, and that's the last thing we want to do. So, although I don't agree with it, I was using the traffic stop as a minimal common denominator as to what to do.
Right, and so I mean, I think that I'm glad you called in. I mean, this is another thing. This was like the tax warrants and warrants for political dissenters when they just would go and get somebody and without any kind of justification would go in and search this person's house for papers. It's the same kind of thing. We're searching for weapons because we don't agree. We don't like this person politically, so we're going to say that they're a danger. I think that all of those are risks that we're running with the red flag laws, and we're going to see a bunch of fights in the future. It's a good call.
All right.
Is that all you got,
John?
John?
I appreciate it. Yes, sir. Keep up the good work.
Thank you, man.
Appreciate you. All right. You want to do any type of wrap up, or you just want?
Yeah. Rick Dodd, thanks for promoting this, and I do personal injury from the constitutional side and right to privacy stuff, and often work with Rick on those cases. But if you got something for him, give him a call. If you got something for me, you can email me at benton@watson.legal. That's BENTON @watson.legal. And you can come see me here at 105 East Main Street in Cameron. That's 105 East Main Street, or give us a call. We get a lot of emails if you have questions, stuff like we just got here. Good questions, you can email me. But make sure you leave your number. You can call at 254-605-4140. That's 254-605-4140.
Ross, outstanding. I can't thank you enough. Very good. And next week, ladies and gentlemen, will be week number 2 of this 10-week program we're doing here with the Bill of Rights, and that'll be the Second Amendment. So, Jonathan, I'm sure you'll be listening to that one. All right, I'll tell you what. Let's take out with one quick commercial. We'll come back with the delicious Janae Goodman talking about honey. See you on the other side. Awesome. Thank you.